Good afternoon and welcome to the National Association for Court Management's webinar, A More Productive Court for a Post-Pandemic Society, generously sponsored by Thomson Reuters. My name is Greg Lambard, and I am a member of NACMA's Board of Directors and serve as Vice Chair of the Communications Committee. It is my pleasure to be your host for this webinar. Before we get started, I would like to go over a few items so you know how to participate in today's event. This presentation will be approximately 75 minutes long, and we're recording today's webinar. The recording will be available for attendees after the presentation and for members on NACMA's website. Please take a few moments to complete a brief survey after the webinar. If you are joining the webinar today on your computer, please submit questions during the presentation by typing your questions in chat. I will address your questions during the question and answer session at the end of the presentation. If you're attending the webinar by telephone, you may email your questions to nacm@nacmnet.org after the webinar, and your questions will be answered. And once again, that's nacm@nacmnet.org. Next, please. Here's our agenda for this afternoon. First, we're going to be hearing about the transformational of the court in Texas. We'll be hearing about Arizona's post-pandemic plans. We'll be listening to improvements made in New Hampshire. We'll be joined by Thomson lawyer Dave Jackson. We'll be learning about things done elsewhere in the UK, Canada, and the United States. And as I mentioned earlier, we'll be having a moderated question and answers toward the end. Next, please. It's my pleasure to introduce our panelists. First, we have Cecilia Rodriguez. She's a former teacher who began her law career as the office manager for the firm of Villarreal and Romero in Laredo, Texas. In 2017, she became court administrator for Webb County Court at Law 2, following the election of Victor Villarreal to the position of court judge. Together, they led the court from a low point into a judicial center of excellence. She will be discussing her court's journey. Next, we hear from Judge Samuel Thoma from the Arizona Court of Appeals. Judge Thoma has served on the appellate bench since 2012 after serving as a trial judge for 5 years. He co-chaired the Plan B work group, chaired Arizona's Digital Evidence Task Force, and currently chairs Arizona's Access to Justice Commission. Judge Thoma will be discussing the post-pandemic future for the Arizona courts. Karen Gorman has been the Superior Court Administrator for the New Hampshire Judicial Branch since 2015. Prior to that, she was prosecutor in California and New Hampshire for 25 years. In her current position, she has focused on operational efficiencies, leading the criminal and civil e-filing and electronic warrant submission. Our final speaker in this impressive lineup is David Jackson, Senior Director of the Digital Evidence Center for Thomson Reuters. He has managed some of the world's largest justice transformation programs, including digital transformation of 78 felony courts for the United Kingdom Ministry of Justice, civil courts in Alberta and Ontario, Canada, and statewide programs in California, Arizona, and New Hampshire. Welcome to all the panelists. To say that the past 20 months have been eventful for court administrators would be, of course, a vast understatement. For a profession that seemed near allergic to technology, being shot into the virtual world, whether we liked it or not, was disorienting, uncomfortable, and not always smooth. Next. Think, for instance, of the poor lawyer staring back. Go back, Eric. Think of for instance, of the poor lawyer staring back at the screen through a cat filter and assuring the judge he was really a human being. Next, please. However, here we are. To think that we can ever go back to an era where we had nearly no virtual events is a non-starter. The question, though, is where does this leave us? What should stay virtual? What have been the positives? What have been the negatives? How can we use our newfound skills and openness how can we use our newfound skills and openness to new ways of doing our mission be used to work on some of the more intractable issues we have been trying to make progress on? Next. NACM has been conducting a yearly survey of its membership to get an idea of what items are the most pressing for court administrators and the courts in general. In the 3 surveys conducted so far, the number 1 item raised by our members has been public confidence in the courts. The first 2 surveys had use of IT as a second-ranked issue, but that dropped now, most likely since we made great gains in that area. Interestingly, but probably not surprisingly, given the past 20 months, the number 2 issue is now access to justice issues. This year's survey findings will be made available on the NACM website in the near future. There is also planning for a podcast on this subject. Next, please. So the natural questions that follow are, how can our new tools and skills be used to increase the public's confidence in the courts? How we can use this opportunity to increase access to justice? There are other questions too. While certain events work well virtually, virtual trials remain a challenge for courts and attorneys. What further innovations might we need to make virtual trials work smoothly and to be less of a resource drain on our employees? Are courts going to consider permanently embracing at least some virtual days for employees? And what changes to human resource policies are needed? Something that has implications for hiring in an increasingly tight job market. How do we maintain IT security when we rely so much on technology? Can the court be fast enough with necessary changes to court rules? Can the courts help legislatures make necessary changes to statutes? And how do we deal with increased backlog of cases? You will probably want to keep these issues in the back of your head as you listen to our panelists to see what you can pull out that can help us answer some of these questions. Next slide. And now I turn you over to our first presenter, Cecilia Rodriguez, to talk about the transformation of the web court at Law 2 and how they have worked to maintain their progress while struggling with the effects of the pandemic. Cecilia?
Thank you for having me here. And thank you for allowing me the time to talk about County Court of Law number 2 and share our story. Hopefully it will inspire you. First slide. Webb County Court of Law number 2 is located in Texas, in the 10th largest county of the state, and its population is estimated at 267,114. According to census.gov, it is composed of 95% Hispanic or Latino, 89.9% speak a language other than English at home, 81% of households have a computer, 66.9% have broadband internet subscriptions, and 20.9% live in poverty. The court took these data points to introduce changes and perfect processes based on the needs of our community. Our daily goal is to provide equal access to justice for all, fairly and impartially, with efficiency and respect, while promoting public trust and confidence in the court. Next, please. Judge Villarreal was selected by Commissioners Court on March 2017 by unanimous vote to effectuate the much-needed overhaul and restore public trust in the court. We came into a serious backlog of over 6,000 cases. It was the worst audited court in Texas for compliances with guardianship laws. It took up to 5 years to conclude misdemeanor cases. And in many civil and family cases, no final orders were filed in 15 plus years. The lack of transparency and the constant delays in cases had shattered the public trust. The community knew that a case in County Court of Law 2 meant justice would be delayed indefinitely. Next slide, please. Once in office, Judge Villarreal's first step was to reach out to the Office of Court Administration, a state agency operating under the direction and supervision of the Supreme Court of Texas that provides resources and information to effectively administrate the judicial branch of Texas. The data and reports requested showed that the court was the worst in the state. And when you are considered the worst, there is a lot of room for improvement. We took each docket and report and notified all parties on the pending matters of the new settings. Defendants had pending cases that were not dismissed properly, even after no speedy trial, stale evidence, or the victim no longer wanted to prosecute or was nowhere to be found. The backlog was such that the ADA was filing matters almost at the 2-year date of incident. This is no longer the case. Misdemeanors are disposed in 3 to 6 months and are filed timely due to scheduling orders and informal docket settings that give the defendants a set time to discuss with their counsel and consider the plea offered by the state. And they also resolve discovery issues or exchange at that setting. Civil matters, Judge Villarreal heard couples talk about the mayhem it had caused in the family's life due to no final orders. A story that comes to mind is in an orders due docket, a couple approached the bench and Judge Villarreal asked, "Are you so-and-so?" And they answered no. They were the children of the parties on the matter that was called, and they were now deceased. This shows you the importance of proper disposition of cases. It now takes uncontested matters 3 to 6 months to resolve, and it allows contested issues to be heard in each docket with sufficient time. No delays, no extraordinary costs to the taxpayers and clients. As the administrator and court interpreter, my time in the courtroom helped me identify technology and courtroom user needs. We immediately translated and provided all of our forms in a bilingual format. For our guardianship compliance hearings, we set 5 computers in the jury room and assisted guardians to register with the state and take the guardianship course, all new requirements. This proved to be successful, and by summer of 2018, we had achieved 100% compliance. To this day, the only court in the state to do so. Other times, it didn't work. An example is when we placed a terminal in the courtroom for attorney use during the criminal dockets due to discovery exchange issues. The electronic request was done direct to the arresting agency. However, this resulted in unexpected charges and the project was not successful. But we never stopped trying, and that's the lesson. Next slide, please. Our work resulted in the designation of a Judicial Center of Excellence on November 15th of 2019. We were evaluated on the following areas. Governance. We revamped our website and we published the court's forms in English and Spanish. We engaged with other county departments to ensure accurate data reflected in the case management system for judicial cost collection. And every docket begins with clear instructions, setting clear expectations for court users. In the access and fairness area, as previously stated, our demographics showed us that the use of bilingual forms would be of benefit to the parties before the court. Before our civil pro se docket, we provide all parties before the court a short instruction guide in English and Spanish of the expectations and court rules they must follow before addressing the judge. We also provide the self-help fillable forms so that they have their final orders ready before the hearing. No need to make a second trip. Next slide, please. Data-driven case flow management area, every single matter before this court is placed on a scheduling order. The trial date is certain and the continuance policy is strictly enforced. This assists the court to allocate resources such as time, jurors, interpreters, and court reporters for complex cases. For court operations, the court has annual meetings to set goals for the year, and we keep each other updated of our progress. As Judge Villarreal's administrator, he and I keep a running log of court needs to present during the budget session. During our first budget request for fiscal year 2017-2018, we included update hardware and software. We did so because good technology means the difference between judicial efficiency and is ultimately in the interest of judicial economy. Next slide, please. For the past 3 years, we took every challenge as an opportunity. We were introspective. We looked for innovation and challenged our ideas. We didn't know it at the time, but it prepared us for the pandemic and what was to come. On Thursday, March 12, 2020, Judge Villarreal and his wife, over dinner, talk about Zoom and purchase a license. On Friday, March 13th, a team meeting was held and a plan was set in place for practice runs. I requested hardware reset to connect via remote to the county network, and all personnel were sent home that Friday afternoon with technology and supplies. By 5:33 p.m., we were notified of the Texas Supreme Court first emergency order, which allowed courts to require anyone involved in any hearing to participate remotely, such as by teleconferencing, video conferencing, or other means. So on Saturday, March 14th, Judge Villarreal announced virtual court settings on social platforms. The following week of spring break, on Monday, March 16th, judge and court staff do multiple run-throughs on Zoom. Next slide, please. By Wednesday, we hosted an Intro to Zoom webinar for attorneys and courts around the state. And on March 23rd, the following Monday, we held our first virtual hearing. During our daily virtual team meetings, we created an alternate email for e-filing and e-service through the Texas filing system, avoiding the potential of ex parte communication with the court by court users. At the beginning, we resolved the issue of receiving, reviewing, and admitting evidence by creating an account on the free online cloud storage. So for each docket, we would create subfolders and give access to counsel in that specific matter. Then we would send an email to counsel with the specific link to the case subfolder. At the end of the hearing date, we would erase everything and start all over again. We would spend around 3 to 4 hours a day creating subfolders and sending emails to the attorneys representing all parties in the case. It was a start, but not a solution. Thankfully, 2 months later, we began using Caselines. And the difference between using a cloud storage system and Caselines reflects in the adversarial nature of our justice system. For example, cloud storage systems are meant to be collaborative. The justice system, however, is adversarial. So Caselines allows for cooperation between counsel, but not collaboration. Next slide, please. The results as of today are over 10,000 hearings called due to no canceled settings, no resets, and no delays. A 20-page standard operating procedure manual for online jury qualifications and civil trials. And my personal favorite, a 100% paperless court. The pandemic has taught us that embracing innovative technology facilitates both the access to and the effectuation of justice. Next slide, please. We all wonder, what is the light at the end of the tunnel? We polled our local bar and 90% of lawyers wanted Zoom to continue indefinitely. So virtual hearings are here to stay, in part, due to the high attendance rates in our criminal law dockets. Elderly widows or wards do not need to travel for our probate law settings. We have heard witness testimony from all around the world, and it has reduced travel costs for expert witnesses in our civil law dockets. If you have a family case in our court, you can log in from work. And we all know that people don't want to be in the same room when they're going through a divorce. Judge Villarreal would like to continue holding online dockets in addition to in-person hearings in the interest of justice. Potential jurors have responded positively to summons and virtual jury qualifications. Online hearings increase transparency. The open courts mandate is a Texas constitutional requirement. You can see any judicial setting, and the effect is an increased public trust and confidence in the justice system. When this happens, we all win. Judge Villarreal always asks, what else can we do? What else can we improve? And as long as you and we are asking those questions, don't worry about the answers. The lesson for all of us, it needs to be always keep trying. Thank you.
Thank you, Cecilia. We have just a moment. I have one quick question before we move to Sam. Someone asked, how and who schedules the time for defendants to discuss their case with counsel?
In our criminal law docket setting?
I assume that's where the question's coming from.
At the beginning and at the arraignment hearing, we issue a scheduling order, and the next setting would be the informal setting. And it's a set date and time where they would, at the time before the pandemic, would be in the courtroom, and the prosecutor would be there, defense would be there and they would talk about the possible plea offer. We also had the probation department and any other department that could benefit from having the defendant right then and there. So at that time, if a plea offer was accepted, paperwork would have been, filled in and filed. And then we would have set it right then and there for a plea date, either earlier than the scheduled court setting for final pretrial hearing, or we would wait, or we would just do it at the final pretrial hearing, but everything was already in place. We still do this virtually. The scheduling order does state the informal docket setting. And what we do is we make sure that attorneys file a conference sheet into each case. This ensures the court that these informal conference settings are being done. This informs the court the client is in contact with their attorney.
Okay, thank you very much. Someone in the chat had asked if the slides will be available after the presentation. We will make them available. We will now hear from Judge Samuel Thomson about Arizona's post-pandemic vision. Judge?
Thank you, Greg, and what a treat it is to be part of this panel. And Cecilia, you have shown the ingenuity and the creativity that you and your colleagues on trial courts have done in your neck of the woods in Texas. And I think sort of by necessity, COVID, the pandemic, has forced forward-leaning trial courts around the country to do that. It's really accelerated I think the adaptation and adoption of technology that might have happened a decade or maybe a generation from now within months or weeks or sometimes days, as your timeline describes from what you did. So let me transition to three things I want to talk about today from kind of an Arizona perspective. A digital evidence court portal concept that started way back in 2016, 2017, which sounds like prehistory, right? The Arizona Plan B work group, I'll talk a little bit more about that and what that is and what we have learned. And then how I think these technology solutions really afford us an opportunity to enhance access to justice. So if we could have that next slide, please. So this is the digital evidence court portal concept that something called the Digital Evidence Task Force that I chaired, again, way back in 2017 had contemplated. It really, and think of digital evidence in the form of body-worn camera footage, for example. That's created in digital form only when a law enforcement officer logs off a shift. It goes into a sort of central repository. There's an audit trail. If charges are referred, the prosecutor looks at it from that same repository. If it's disclosed after charges are filed to defense counsel, the defense counsel can look at it at that same through that same repository. But if you want to use it in court, at least historically, the only way you could do that would be to put it on a thing. And either this thing would be a CD or a thumb drive. You would then take that thing to the court and the deputy clerk would mark it in like you would a paper document, and then it could be used in court. Our thought was, hey, what if, like with electronic filing and with transcripts that we're seeing these days that are lodged electronically, not in paper form, what if you could use electronic filings that would cross the threshold from the parties to the court in the same format that they've always existed? What would that world look like? This seemed like science fiction. Next slide. If when we looked at this in 2017 as part of this Digital Evidence Task Force, and we made some recommendations about this Jules Verne sort of crazy idea, and those are located, including in the Washington Law Journal there in an annotated version in our final report that we issued on the 1st of October 2017. That in turn was the product of a Joint Technology Committee white paper in 2016 that was a call to action saying, hey, courts, you're going to have a big chunk of data that you got to be able to account for and work with, or you're going to have a very bad day. Actually, you're going to have a very bad series of days. And in the course of doing this, in the course of thinking of this sort of, pie in the sky idea, we ran into this entity then called Caselines that was a standalone entity. I met David Jackson completely by accident in Salt Lake at Court Technology Conference. And it sounded like, and in fact, in our final report, we footnoted that this Caselines entity sounded like it was doing something that we were sort of imagining. But at the time, it was only doing it in Great Britain or parts of Great Britain. Next slide. So then our technology folks in Arizona did a whole bunch of internal work over a period of years, really, because remember, our final report was in October of 17. And then some things changed. COVID hit. Caselines became first affiliated with and then owned by Thomson Reuters, and our Judicial Council in December of last year approved a pilot using this digital evidence portal concept in Arizona. It is now being piloted in both rural and urban courts, general jurisdiction and limited jurisdiction courts around our state. The goal is to have that rolled out in all 15 Arizona counties by the summer of 2022. The resource page, which shows both successes and stumbles, is listed there for your reference. And to anticipate a question, because I talked to a deputy clerk, it's like, all right, Thumma, sure, this is great for pictures and videos and documents that can be in electronic form, but how about the gun? How about the 22-pound bale of marijuana? How about the baggie containing the drugs? Well, I think there always will be room in courts for real exhibits, but I'm told that by some of our clerks that the parties are literally stipulating to be able to use a picture of the gun as opposed to the gun itself, unless the gun becomes material. So even physical things that you would think ordinarily would need to go in that same evidence locker may be usable through this digital evidence portal concept. Next slide, please. All right, so the next topic that I want to talk about is our Plan B work group. Now, the full title of it is the COVID-19 Continuity of Court Operations During a Public Health Emergency Work Group. So you get why we call it the Plan B work group, the thought being that Plan A left when COVID arrived. That was appointed, our work group was appointed in March of 2020, really at right when COVID hit, by Chief Justice Robert Brutinel. Marcus Renkensmeyer and I co-chair that committee. Marcus is a name that is delightfully well known to many NACM members, and Marita Mathis was just an incredible sort of part of this effort as well, and I think she's on the Zoom today. We had a ton of terrific trial judges, clerks, jury commissioners, court administrators, and genuinely other miracle workers throughout our trial courts, both general and limited jurisdiction. One member of the State Bar of Arizona who was actually a staff member, and then other members of the Administrative Office of the Courts. We met about 60 times most Wednesdays, more as an information sharing aspect than anything else. But we also came up with some white papers, and let's go to that next slide if we could. So here's what we have published. We came up with some best practice recommendations that, again, seem like prehistory. Jury management recommendations. What happens, the July 1 protocol, if someone comes to the courts and is exposed or is symptomatic for COVID? How do you want to deal with questions, issues about vaccination? But then I really want to focus on this last report. It's about a white paper. What would we recommend as a Plan B effort, given the experience of those members on that group, be retained? And about 90% of those recommendations really for best practices and technologies are technology based. And I want to drill down a little bit deeper. If we could go to that next slide on this June 2nd, 2021 report. Recommendations really kind of fell into 5 buckets. And these are all the same circles, but technology is definitely a huge chunk of this. and is really at the corner of it. But access to justice, as we'll find out in just a second, are awfully important. Jury and trial management, using technology both in pretrial screening for potential jurors, and then jury selection, and perhaps even jury participation, both in jury trials as well as in grand juries. Health, safety, and security protocols, and then communication strategies, disaster preparedness, sort of recognizing an ounce of prevention can be worth a pound of cure. Next slide. In the course of doing this work, we did a survey of the branch, and it was in May, mid-May as indicated. We sent surveys around to the entire members of the Arizona judiciary and staff, and we got about a 40% return rate, which was, I thought, pretty extraordinary. We included as an appendix in that white paper, which is available on the court's website, although I'll come back to that in a second, all those responses that we got verbatim, including some textual responses. And I'm delighted there were no curse words in any of the responses that were listed in there, but we included them literally verbatim, sort of unvarnished, and they were extraordinarily instructive. If we could go to that next slide. This is a little bit of a busy graph, but one of the things, and again, this is of the branch, right? So not lawyers, not the public, but the judicial branch. To what extent do you foresee continued use of the following court technologies after the pandemic recovery? You know, first and foremost, electronic filing. Well, Arizona in part had been using electronic filing for quite a long while. During COVID, it was expanded sort of statewide in our superior courts, and you get 93% saying that's either somewhat likely or very likely to be used going forward. Digital signatures, no surprise there. Online cash payments, and I want to note that one and then come back to it later, because I've got a couple other surveys that I want to focus on that specific point. We have Pay Near Me, some offsite cash payment options as well. Then we get to what sort of you would think about in court: live streaming, remote services, digital evidence. You know, fully 70% thought that made sense. And then online dispute resolution was actually fairly low. That trailed. I was a little bit surprised by that. But again, this is from the perspective of the court itself, not the court users. We will then, though, turn to another survey. We actually were the beneficiaries of two other surveys. If I could have that next slide. Our State Bar of Arizona circulated a survey to its members and got survey results back, and that was as of July of 2021. Unfortunately, our efforts to coordinate to see if our questions could be either identical or nearly identical failed, but we had some pretty similar questions. Response rate for this was a fair bit lower, but the universe that they started with, I think, included maybe 15 or 16,000 members of the State Bar, recognizing they got several hundred responses back. But so the users of the court systems, and including technology-based platforms, the attorneys, what benefits did they see? And the responses included, you know, almost 60% said, hey, I'm not traveling as much. I'm not in a car as much. I can use my time more efficiently. It's cheaper. I'm more productive. Almost half said that. Enhanced court access, which was interesting to me. About 20% thought that was good and helpful and a positive thing. And then, you know, far lesser numbers with respect to access to their files. But lawyers, and they some other questions were asked, and clearly they saw some downsides for technology, some risks, and that's okay. But they saw a real advantage for us to be able to do more as a system collectively, and lawyers as participants in the court system using technology. Next slide, please. And then the third survey that we did, and this and all these three surveys, along with our white paper, will appear in the SMU Law Review Forum. We're publishing these together later on this year, actually, hopefully next month. So, and there will be three appendices. The first one is our survey to the branch in May. The second one is the truncated survey of the Arizona members of the Arizona Bar, although that was featured in an Arizona Attorney article that came out out just within the last few days. And then this literal public opinion survey. This is a phone-based survey, random survey. 500 people were asked their points of view about use of technology in the courts. And again, the questions were slightly different because we didn't want to just limit it to folks who had experience with the courts, but their perceptions of that. What's the first thing that's very important for these individuals? To be able to pay court fees or fines online. Now that surprised me. About 70% said that's very important to them. But you see some other things, being able to sign court documents online, electronic presentation of documents to the court, all really sort of forward leaning on use of technology in the courts for folks who may or may not have had experience in the courts. We asked one more question, or actually I asked several other questions, and they'll all be reported out in that SMU Law Review piece, but a digital divide question. How many people thought that they had, what percentage of people thought that they had sufficient access both with broadband internet and with hardware to participate effectively using remote technology? And 9 in 10, so about 90%, said that they thought they were able to participate appropriately, that they had the right Wi-Fi connections and the right hardware. That surprised me. That was a fair bit higher than some of the numbers we heard just a little bit earlier, but encouraging. Again, a random public opinion survey in Arizona. Next slide. So are all these things a panacea? No, they are not. They come with complications, without question, and they come with challenges. We've talked some about the digital divide. Is it right for us as a court system to expect, our staff and the public can simply intuit how to use these things? No. We need training and education that goes along with this. Special user needs. How do we deal with someone who is hearing impaired or is sight impaired? How do we address interpretation issues, language, English as a second language? There are opportunities there. There are solutions for that, but we need to account for those. Funding, who's going to pay for all of this? And again, change. The branch is not always known as being forward-leaning and eager to implement change for the sake of change. But I think if COVID has taught us anything, it has taught us that we can and hopefully will implement technology to better serve the public. One of the survey responses from a member of our branch that caught my attention was, we need to start thinking of the court as a service instead of a location. And I think, for me, that really had traction. And if we use that approach, imagine how many more people we can serve when we're serving the public. Next slide. So along with these challenges, let me submit, I think there is an enormous opportunity to better serve the public, like I said, and an enormous opportunity to enhance access to justice. These are based on hard numbers just for one type of hearing. It's the initial hearing in an eviction action in the 26 Maricopa County Justice Courts, right? So there are 26 of those in Maricopa County, where Phoenix is located, which is a pretty geographically large county. And at least one of those courts, there's no public transit to the courthouse. If you look at, and you look at the data before and through March of 2020, when only face-to-face appearances were allowed. The failure to appear rate for the initial hearing on an eviction action by the defendant, by the tenant, ranged from a third, maybe 30% to 40%. So at its high, 4 out of 10 tenants just didn't show. And those cases likely would be resolved by default. Just when you allowed remote appearances from March of 2020 forward, and that could be by phone or video, depending on the specific courts, those numbers trailed down pretty consistently. The low there in February of 2021 was 14%, 14%. So it went from a high of 40% of failure to appear to a low of 14%. So from 4 in 10 to 1.5 in 10. How those cases were resolved on the merits, I don't know. but they weren't resolved by default. And isn't this an opportunity? And you can cite many other examples in juvenile court and family court and others, how using technology can expand our reach to better serve the public and to provide more access to people in need of court services. Greg, back to you.
Thank you, Judge. That was very interesting. See up there questions for the judge can be directed that way. We're next going to move to Karen Gorman from New Hampshire. Karen?
Thank you, Greg. And thank you for allowing me to come talk to you today about what we've been through over the course of the last year and a half with COVID and where we plan on going in the future. In March of 2020, our governor issued an order effectively closing down businesses and schools and leaving a lot of workers to be home. Next slide, please. I'm sorry, I forgot that for the very first one. That order immediately had an impact on the court, as it did around the country. We had to cancel all of our jury trials. We suspended grand jury proceedings. We had our staff having to stay home with school-age children, and nobody was able to come into the court, including law enforcement, to drop off search and arrest warrants. So we immediately had to challenge the assumptions of providing a service to our constituents, our court users. We were used to doing it in person. We had to challenge that assumption and see how we could stay open and how we could provide services in a remote setting with people not coming to court. Next slide, please. I'm going to focus on 4 different areas that are traditional court services that we use, that we provide, where someone has to come to court and now all of a sudden they couldn't. So the first will be, I'm going to talk about how we handled grand jury, next jury trials, then hearings and warrants. In New Hampshire, all felony cases are required to be presented to a grand jury by law in the county of jurisdiction by law. By rule, all felony cases are required to be indicted within 90 days of the filing of the initial complaint. So we used statutory changes, we used rule changes, and we used process changes to keep our grand juries, or to get them back up and running as quickly as we could. The first thing we did is sought a statutory change to allow for a statewide grand jury that would have jurisdiction over all counties. That would allow those counties that we were not able to hold grand jury in and a venue where they could present their cases. The second thing we did is amended the court rule and lifted the 90-day deadline to indict. We wanted to make sure that we could process these felony cases and move them through the system. Next slide, please. We knew we couldn't go on till the end of the pandemic without the indictments and moving cases forward. One of the concerns we had was how would we get grand jurors to come and be willing to serve after telling everyone to stay home from court for so long. We drafted about a 2-page letter that went out with the jury summons, and it detailed all of the COVID precautions that we were taking in the courts, including what the screening process was going to look like, what our cleaning protocols were, that we were providing lunch for them in individual bags, that they would be socially distanced. And surprisingly, we had very few jurors apply for an excusal or a deferment because of COVID. We set up in a well-ventilated courtroom, one of our newer courthouses in the center of the state. Prosecutors appeared remotely. Law enforcement witnesses appeared remotely via WebEx into the grand jury room in one county. And we were able to draw grand jurors from around the state because our jury management system is fully electronic. So we were able to do that without having to reconfigure. We had our grand jury foreperson sign the indictments electronically and process them back to the local courts. What we did learn from that, even though it worked to keep our system moving during COVID, is that our local courts like to have control over their grand juries. They want to have that contact. They want to know their cases. So this system, while the statute is still on the books, is not one that we are currently using. We stopped using it in May of 2021 when all of our courts were able to reopen and allow grand jurors to come in. Next slide, please. The second obvious one is jury trials. I'm sure that most states conduct jury trials similar to what we do, where we have a large pool of jurors coming in on day one. Our jurors then watch a jury video and then are split up and sent to the different courts in different panels. Our goal was to keep as many jurors out of the courthouse as possible until they were needed for trial. We placed the jury video on our website and sent out a survey to all of the jurors, who were then required to watch the video through the link and then certify that they had watched that video before coming to court. We ruled out fully remote jury trials very early as a possible solution for a number of different reasons. But we did want to keep the jury selection process as remote as possible. Next slide, please. So we did a couple of different things here. We reduced the age for automatic excusal from 70 to 65. We told our judges they could liberally use the excusal process. But really, we did not see many excusals due simply to COVID or people being afraid to come into the court. We also sent our pettit juries the same COVID letter detailing what we were doing, so that they would feel safe coming into court and that they could trust the process and that they would be taken care of. Instead of sending the jurors to the courts for panel discussion and panel questioning by the judge, we implemented a supplemental questionnaire with case-specific questions that the jurors filled out electronically. That allowed the judge to conduct WebEx hearings with the attorneys for the for-cause challenges. The pool that was left were scheduled for individual voir dire at different times in 10-minute increments coming into the court until they had a full panel. The other problem with juries is we are required to provide public access to jury trials, and it was difficult to know how many members from the public would be interested in coming in. So we set up a live streaming service in every one of our courthouses and had links on our website to a live stream of the jury trials. For domestic violence and sexual assault trials, we did not want those live streamed for obvious reasons. So we remote WebExed the jury trial into an empty courtroom in the courthouse. So they would come to the courthouse, they would sit in a different room, socially distanced, and watch the trial on video. And while the jurors absolutely loved this process because they only came to court when they were needed to serve on a trial, unfortunately, we could not maintain the process because now with trials fully ramped up and a lot of them being scheduled, the communication with the jurors was pretty extensive. It was a drain on our court staff. The supplemental questionnaires were a lot of work for the attorneys to review, and they felt that they didn't have time to do all of that, and that the additional steps made it very difficult when we returned to full operations and scheduling a lot of jury trials. We do hope to go back to the subsequent questionnaire and the remote watching of the video once we are a little more used to conducting the numbers of trials that we are doing. Next slide, please. Hearings, public hearings. I think this was discussed a little bit by the previous presenters. Nobody wanted to come to court and nobody could come to court, so what do we do? When COVID hit, we did have the capability for remote hearings for our incarcerated defendants. We had a link between our jail and the court, but we had nothing else in place for remote hearings, and we lacked the hardware to conduct hearings remotely and the process. We had no process in place. Next slide, please. We very quickly deployed mobile WebEx units to every courtroom so that they could all hold remote hearings, and we developed a training plan for staff and judges on the use of WebEx. We also held webinars for attorneys and self-represented litigants, and we had videos on our website for how to use the system. We encountered one problem that when we started doing remote evidentiary hearings, and that was how, if the hearing was going to be remote, how are they going to get their evidence submitted? And it was a little bit chaotic in the early days. We had litigants emailing the court, emailing the clerk, emailing the deputy clerk, emailing evidence to the court monitors. And it was very, very difficult for us to process and find evidence. Video evidence was almost impossible because it couldn't be emailed. So some evidence was dropped off in a Dropbox outside of the court on the thumb drives that Judge Thumma was talking about. That led us to another thing Judge Thumma discussed, which was COVID forced a lot of immediate action. We had gone to a fully electronic court in December of 2019. We rolled out civil e-filing in 2018, and we just finished our criminal e-filing project in December of 2019, which was very fortunate for us. We were able to make it through COVID with being fully electronic. When we rolled out electronic filing, we specifically did not include evidence submission in an electronic manner, in part because we simply didn't have the capacity at that time. But we did make a promise to litigants that we would look at evidence, a digital evidence format down the road. We didn't guarantee any dates or times. COVID forced the issue, and we signed an agreement with Caselines, and we are currently piloting Caselines in 2 counties. The second county just is going live on Monday. We've just finished the training in the second county. And we're piloting it with hearings, and then we will move to jury trials. But Caselines fit the need that we had, and it allowed us, well, interestingly, we had a new Chief Justice appointed, new Chief Justice of our Supreme Court appointed just as we were talking about Caselines. His very first meeting with me was asking if we could move forward with a contract with Caselines, and after discussing the project and the need, he immediately approved it, and we were able to move forward. Of the lessons that we learned through this, we are very excited to have a digital evidence management system in place now, and we are continuing remote hearings. There's an administrative order that we have that requires certain hearings to be held remotely, because the feedback that we got from attorneys was essentially they want to continue as many remote hearings as possible. So we do have certain hearings that are required to be remote. We will be using Caselines for the remote hearing for the digital evidence submission, and we use WebEx to conduct those hearings. Next slide, please. The last piece I want to talk about is our warrant process. Obviously, during COVID, law enforcement couldn't come into court to present search and arrest warrants to our judges, which was our process. Paper warrants, coming into court, looking for a judge to sign a warrant. Just prior to COVID, the Superior Court had agreed to take felony warrants, which had traditionally been a circuit court function. So the confluence of Superior Court taking warrants when law enforcement wasn't used to it, along with having to email warrants, which is a non-CJIS compliant manner of filing electronic documents, it was a very difficult time for law enforcement. They weren't sure where to send the email. They were concerned because it was not a CJIS compliant manner. So we worked to come up with a brand new format for warrants statewide that is now the permanent solution for warrants. Next slide, please. What we did with warrants is we centralized the submission of warrants. So instead of law enforcement having to find a court, drive to a court, and drop off their warrant, either come back later and pick it up or meet with a judge and get it signed then, we centralized the process. We now have 2 warrant clerks in our administrative office of the courts who handle all warrants that are submitted. Law enforcement sends an email to one email address for search warrants, arrest warrants, circuit court, misdemeanor, superior court, felony cases. The centralized warrant clerk then sends an upload link through a CJIS compliant law enforcement enterprise portal Law enforcement uploads that warrant. It goes directly into a judge's queue for review. The judge signs it electronically, and then our warrant clerks send a download link back to law enforcement to have their signed warrant. The process, like I mentioned, is fully CJIS compliant. Our IT department did not have to be involved because the law enforcement enterprise portal is run by the FBI, and they have a 24/7 help desk. So that was a huge piece for us because our IT department is strained right now with all of the projects we have going on. One of the features that I love about this process is that we are able to spread the warrants statewide among our 21 judges. I did have to go out and train law enforcement statewide, which was a huge undertaking. We were able to get a statutory change allowing the electronic signature under penalty of perjury, so judges don't need to call the officers to take a telephonic oath. But that process is a permanent solution that was really brought on by COVID, and the new process is we're getting a lot of thank yous from law enforcement and from our judges. So thank you for having me talk to you about what we've been through over the last year and a half, and I will turn it back to Greg.
Thank you so much, Karen. Very interesting. Let's hear from David Jackson from Thomson Reuters. David?
Good afternoon, everybody. Greg, thank you very much. Could I have the next slide, please? So we've heard over the last 45 minutes or so from three really excellent case studies about the differences and the processes that different people have been through to digitize their courts and particularly to bring digital evidence into the courtroom itself. I want to spend just a few minutes reflecting on some of the experiences that we've had around the world, starting with my experience back in 2015 when we were running the project in England to digitize the felony justice system. There were 78 courthouses across the whole country, and those were fed by 40 prosecutor offices. The British model is very similar to the American model with just one difference. The prosecution function is modeled explicitly on the way that the DA function works in the United States. And the only material difference is that the British function is a nationalized system. There is a single Crown Prosecution Service. They had 40 offices across the country. What we saw was that the implementation of digital evidence in the courtroom led immediately to a dramatic reduction in the number of hearings. And that came about really for two reasons. One is that case management hearings could be pretty much automated. A lot of the work that went into case management conferences before the hearing itself all managed to get into paper, with all of the parties being able to see any relevant evidence in advance in order to make appropriate management decisions about how to manage the case progression. So that cut a lot of the unnecessary processes out. And the second big impact was the avoidance of continuation. So what we've seen is that once all of the digital evidence is in a single repository, and as somebody mentioned earlier, allowing not collaboration but cooperation, the parties can see the evidence, and public defender and a district attorney can talk in advance. Having seen the information properly, they can consider what the plea might be, whether there is going to be a plea bargain, etc. And most critically, we avoided continuation hearings. And actually very, very early on, I think it was in the first week after we launched in the first pilot courts, I sat watching just to see how things would go. And I watched a young attorney from a defense attorney stand up in front of a judge and say to the judge, pulling himself up, and say to the judge, "I'm sorry, Your Honor, but we can't go ahead with this because we haven't been provided with all of the evidence." At which point the judge tapped his nose and said, "Miss Jones," it was a young lady, I'm afraid, "Miss Jones, it says here that you saw this information at 9:26 a.m. last Friday morning. Now, can we proceed?" And that was the end of it. And within weeks, we had seen that the lesson got out across the community that you could no longer play games. You had to respect the judge. You couldn't misuse the court's time. And so you can see here, there's a quote at the bottom for those of you who can see the slides, that the judge who was leading that project, Lord Justice Fulford, documented a decrease of almost 50% in the number of hearings that were required. So massive savings. But the other thing that we saw was a massive saving across the system, and particularly for the prosecution staff themselves. They found that the time that they spent actually putting together the file for the court dropped by as much as 80%. And it's the sort of things that Judge Summer mentioned a moment ago, that if you have to get video to the court, somebody, an evidence technician in law enforcement or somebody in the prosecution office, has to sit there and burn DVDs, and then burn another one for the public defender, and then burn another one because one got lost. And all of those things, they take a huge amount of time. And it was that cut in the time that allowed people to cut their backlogs and improve the productivity of the process. Next slide, please. And one of the things that we've seen is that the benefits are not just related to the courts. We focus very much today on the courts themselves, but the real benefit is your ability to contribute to the overall improvement of justice within an entire county, within an entire city, across an entire state. The impact is huge. Starting with the work-life balance for an ADA, one of the things that we see is less time wasted in court, less time wasted traveling to court, and we've seen statistics on all of those things. And we've seen the popularity in the surveys that Judge Summer showed as to the real impact. But that translates into people who are happier in their jobs. So it cuts the number of people who resign because they're simply burned out. It cuts the wastage of people's careers. What we also see, and we've seen this very much in Canada, for instance, where we're rolling out, is that court staff are now being freed up to do more useful things. One of the things that's been most noticeable for me is that courts never really save much money from putting in these systems because the demands are too great. There is just such pressure on the courts today to deal with backlogs, to deal with so many different challenges that you never really release money. But what you do is you enable yourselves to do things that you couldn't do otherwise, or do the job properly. And we see that particularly with counter staff who are no longer tied up in the back office and can be there to support pro se litigants and to provide more useful advice to people coming into the courtroom. But the other thing that is quite remarkable, and I think I'd like to call out for those of you who might not even have seen this report, but a superb report from the National Centre for State Courts that looked in detail at the actual facts about what happens when you have continuations. The words on the quote are mine from the report itself. I've simply just summarised some of the key findings. And the key finding is that, as you can see there, for every 100 felonies, there's going to be today 57 continuations. Now, some of the people who are subject to continuation are in detention, and therefore the immediate knock-on effect is in number of detention days that the county is paying for. And the typical length that they found is that a continuation typically means an extra, on average, 31 days in detention. So at $100 a day, we're talking about $3,000 on average per additional detention, per additional continuation. So we're talking about a very, very substantial effect. And one of the things that's not called out in the NCSC report, but is fairly obvious when we think about it, is the impact on different groups in society. Because the people who are refused bail, the people who are in detention, very often are the weakest members of our community. They're tend to be less well off. They don't have money to find representation. They're very often people of colour. So anything that can be done to improve continuations that can have a knock-on effect on detention days has a much broader societal knock-on effect. So what I would say to everybody here today is the benefits to the courts, as we've heard in the 3 previous presentations, are all very substantial. But it's not just for the courts, it's the impact on the justice system as a whole and the impact on the budgets at county, city and statewide that are very substantial. Greg, back to you for any questions.
Thank you very much, David. Thank you all the panelists. It was very excellent presentations. We don't have too many questions. Cecilia, there's two that probably I think are directed to you. One, will we share your outline on SOP for online jury qualifications? Someone else said, can we find more information regarding the virtual jury qualifications you employ online? So it looks like you got two customers to talk to and you get a chance. We have a question. Do the panelists expect ongoing and expanded use of video remote interpreting and simultaneous interpreting, the best VRI option when possible? That's directed at anybody.
I can answer. For our court, we used VRI for sign language interpretation before the pandemic. Due to no local resources, there was no certified local sign interpreter in the county. And San Antonio is 1.5 hours away from here. So it would cost the court travel time for, maybe a 5-minute hearing. So yes, we will continue to use VRI for sign language interpretation for in-person hearings, hybrid hearings, virtual hearings. Now, in regards to Spanish language interpretation, I do consecutive interpretation, and due to the fact that we call the docket, and when we do our well of the court, which is Zoom, you see over 100 screens. But if we have maybe 1 or 2 cases, and I know that one of those individuals needs interpretation, we do send emails to the attorney and ask for that person to specifically log in the second device so that I can go ahead and do some simultaneous interpretation through Zoom. We tried doing the channels at the beginning. However, sometimes attorneys had their Spanish speaking client next to them, and you really can't do much with that scenario. So yes, we will continue using that. And in regards to the SOPs, I have requested clearance to share. So just please put down your email and I'll get back to you.
And maybe one more question before summing up. I started with the main topic in our members' minds for the past perhaps 4 years is the public's confidence in the courts. Judge, and then maybe Karen next. Do you think the changes we've been making, kind of forcing the making, so to speak, have helped to enhance the public's confidence, or is there an opportunity we need to seize on?
Greg, it's a work in progress, right? Which is a non-answer to a really, really important, really good question. But let me start with a baseline and then say why I think what courts have done are an extraordinary sort of opportunity and a discharge of our obligations that I hope continues. If you look historically at surveys on confidence of the 3 branches of government, public surveys, to the extent folks understand that there are 3 separate branches of government, which is a somewhat different topic, the courts typically are at the top of that list, right? And I hope that we do everything that we can to earn that trust and to continue to earn that trust and be at the top of that list. What I think this digital accelerator that is COVID has allowed us to do is required us to take a new look at what it is we're in the business of doing. And I think that's serving the public, at least I hope it is. And I hope it is being creative in ways to make dispute resolution accessible for those who most need it. And I think it has made the courts more vibrant, more relevant. Let me go back 18 months. If I had a dispute with a vendor on Amazon, I could resolve that really pretty quickly. And that didn't require me to go to a courthouse to pay someone money for the privilege of suing someone else, to then have that matter sort of rattle through a process that might get resolution a couple of years later, right? And I think with court-affiliated online dispute resolution, with electronic filing, with the digital evidence portal concept, with allowing the record to be created remotely, both with court interpreters and at times court reporters or transcriptionists, we have caught back up some from what ground we had lost at a time, for a long time, for centuries, where we thought we administer really, really, really good justice, 8:30 to noon, 1:30 to 4:30, weekdays, weekends excluded, holidays excluded, things like that. And I think the technologies that we all have talked about have allowed us to be even more germane and important to resolve those disputes without, I think, in the main, losing any quality. So I sure hope so, Greg, but that's a long-winded answer to a really important question.
Karen, do you have anything to add to that response?
That was a great response, Judge. I would also add that part of the reason I think that we are gaining confidence in the courts is we are meeting the expectations of our litigants, our lawyers, our law enforcement officials by providing digital services where they don't have to leave their office or hire a messenger to file pleadings. They can organize their evidence using a digital evidence management system. We are providing the way for them to view that evidence in court or in a hearing. And we're providing law enforcement the digital ability to get warrants signed. We're meeting them where they are. This is an expectation that I think the public has in 2021, and we're meeting that expectation. And I think things are getting done faster, but just as good.
All right, folks. Well, again, thank you all for your excellent presentations. Again, we need to, while I think we are have a public that does have a good deal of access to IT, we still have to stay on alert for those who can't meet us with whatever resources they have and figure out how we're going to improve our ability to get them the access to justice that they deserve. So just in a variety of success stories and handling the challenges posed by the pandemic, we've also seen how the reaction of the courts to this situation has enhanced our ability to accomplish our mission. I leave this webinar buoyed by the fact that we took the necessary steps and the legal community and the litigants have come along and adapt along with us. I want to thank everyone for participating in today's webinar. Please allow me the opportunity to share one or two announcements. For non-NACM members who are participating in today's webinar, we encourage you to consider membership. NACM is the largest organization of court management professionals in the world. In addition to providing quality education at conferences, with membership, you also have access to podcasts, webinars, publications, guides, and other materials that inform members about best practices, innovations, and issues affecting courts today. NACM also provides a forum for working with other colleagues in the profession to improve the administration of justice. Please join today at nacmnet.org. Information about NACM and more can be found at nacmnet.org. More information about Thomson Reuters can also be found. I believe there's a next sign coming up, but go back, Aaron, I apologize. I wanted to make sure we mention our upcoming conferences. We have our mid-year coming this February in Bellevue, Washington, and then our annual in 2022 will be in Milwaukee, Wisconsin in July. Thank you, Aaron. Next. And again, thank you to Thomson Reuters. We appreciate you sponsoring this webinar. There's information there for folks who would look to reach out to them for either federal or state and local matters. On behalf of the National Association for Court Management and Thomson Reuters, thank you, panelists, and thank all of you for joining us today. Thank you very much.